and good morning, everyone. My name is Jillian Bender Cormier with Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar, using AI responsibly in the workplace, legal guidance, bias mitigation, and policy design. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I will be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link as well as a copy of the slide deck will be forwarded to you. We have an incredible expert sharing with us this morning, and to introduce him, I'll pass it over to our VP of Healthcare Risks, Keck Royes. Welcome, Keck.
Thank you, Jillian. I'm excited to introduce Trevor Hodson, who brings more than 25 years of experience advising executive leadership and HR teams on employment and labor law strategy, compliance, and risk management. He partners with management on critical workplace issues across the employee lifecycle, including hiring and termination decisions, policies and handbooks, investigations, leaves of absence, wage and hour compliance, employee benefits, and labor relations. He also represents employers before courts, administrative agencies, and the National Labor Relations Board. Trevor is known for helping leaders resolve disputes efficiently through arbitration and mediation. It is my pleasure to introduce our speaker, Trevor Hodson.
Hi, good morning. Thanks, Keck. I really appreciate that and appreciate the opportunity to take some time and talk about this AI stuff that we're all grappling with. I think throughout this presentation, I'm going to be adding in some anecdotal thoughts because quite candidly, we're dealing with this in our workplace just like everybody else. And it does feel like it's real-time movement on how we address this new technology that we all have access to. And it feels like it's impacting all of the industries in a lot of positive, but sometimes challenging ways. So this is our firm. These are our attorneys. And this is me when I was younger and better looking. So I want to jump right in, but I do, as we said at the beginning, I would love to take questions as we move along. That I think helps everybody. And I don't find it distracting. I really think that it's the best way to learn and understand the concepts. I'm also going to suggest that I am not an AI expert. The nuances of this technology obviously are outside of my expertise, but we do use it. I use it. I know that others use it, and we've been grappling with these issues for a couple of years now, trying to figure out how best to protect employers and companies as they engage with the AI. So although I may not be a tech expert, I do feel like there's a lot of experience that I've had already in trying to grapple with these issues. So anyway, like any good attorney, I want to start off with some statutory definitions. The law has attempted to define what it is we're talking about. AI is listed there, and then generative AI is the AI that can generate stuff, right? Text, image, video, audio. I think we all kind of know intuitively what this is, but the law itself is trying to articulate what it is that we're grappling with here. So we're going to talk about this in sort of three contexts: confidentiality, which is a big one, the liability that we have as we use AI, and then there's some regulations and things that deal with discrimination and maybe how it gets used in the employment determinations that are made, and there's some regulations that we can pull from. I think in a lot of this, we're looking to newer case law. We're looking at maybe trends that we're seeing in the law versus real clear, bright line types of principles. And so, but I do think there are certainly reasonable trends that we can look to and see where things are going. And then what we can do as corporate executives, HR folks that are trying to come up with the right policies and how to deal with this in the workplace. So let's get going. Confidentiality, I think, is a great place to start. So probably we all know this, but I think that there's some, like, we need to understand, and there's actually a recent case that I'll talk about in a second that illustrates this, but the use of the AI, the inserting confidential information is going to jeopardize the confidentiality, the protection that information may have. So we have to figure out how are we going to share information in this new tool without jeopardizing the confidential nature, the protected nature of the information. So let me just jump into, there's a recent case that came out. One of the federal district courts decided that when a client in an attorney-client type relationship, when that client took the information they received from their attorney and put it into AI for whatever summary reasons, or maybe they want to get a second sort of assessment of what the attorney said, in doing so, they have now jeopardized the attorney-client privilege. And that information now is no longer protected as confidential, because they said that you're basically sharing it with a third party, right? So any confidential information, we'll talk about the Uniform Trade Secrets Act in a second, but all confidential information needs to be kept confidential. That's always going to be one of the components of protecting any information, is that we take reasonable measures to make sure that it's kept confidential. And that's obviously true in an attorney-client type of setting. I don't think that the client anticipated that in running the attorney information through their AI tool, whatever it was, that would jeopardize the attorney-client relationship. But the court found that it did. And so I think that's indicative of how courts are going to look at this type of engagement with this tool. It's like you're sending out the information to the world, right? You've lost control of it, and now it's no longer confidential. It's just shared public information. And I don't know all of the nuances about how that works, but I certainly understand that AI works on itself and uses models. And so it takes information that it's given and uses that in other searches or other projects or other systems that it creates. And so it makes sense from that perspective that information that's shared is no longer confidential. But I don't think people are thinking through what that means with regard to the information that's being shared. Certainly in a law firm, we have obligations to keep things confidential. And so we can't just wholesale take, a bunch of documents that have confidential information from a client and throw it in to an AI tool and say, I want you to process that for me. I want you to sort it for me. I want you to, analyze it for me. That is just, it's going to jeopardize the confidentiality. So number one is we now have to think through what kind of information in a corporate setting, in a business setting, what sort of information are we going to offer? What data are we going to put into the AI, understanding that it is going to jeopardize the confidentiality of it. So clearly defining what confidential information is, I think, takes on a whole new meaning, because it's very easy for people to access AI now. And so it makes, if we have employees that have confidential information and they're offering it up in an AI setting, how is that impacting the information? How is that jeopardizing the protections that we expect?
And Trevor, we have a question that's come through.
Perfect. Let's
Um,
go.
is there confidentiality in paid AI? Is that specific to the vendor or the AI product that's paid?
Yeah. Yeah, that's such a great question. And we'll talk a little bit about that. But each paid AI is going to have an end user agreement, right? And in all of the software that we access, right, we make some sort of agreement to use it. And sometimes that's just clicking a button, but there are some parameters that are associated with the use of the tool. And in those end user agreements, right, they are going to tell you, like, if you read them carefully, they're going to say, whatever you give us is ours, and whatever you give us, we're going to use another. I mean, they're going to say that outright. And so one of the models to protect the confidentiality is, and what I've understood is that there's an industry of how do you use AI and protect the confidentiality, so you have more closed circuit, right? It's not huge communities, but it's closed to your corporation, closed, right? But that needs to be in the agreement that you have with whoever's developing that for you, right? You need to address, or it needs to be addressed, how this information is going to be used and how it's going to be kept confidential. So certainly just going to a public AI sort of resource and then throwing your information in there, you probably signed in some form or another, you clicked on something that's have all my stuff and you don't have to keep it confidential. And so, yeah, the answer to the question is that is one way to get to restrict, right? We're trying to protect and restrict this information. And one way is to make sure that the agreement that you have with whoever you're purchasing the tool from is clear about their obligations to protect the confidential information. It's a very astute question. That's exactly what you need to be thinking of.
Thank you. And I do have a follow-up question.
Please.
Uh, so who holds the liability if because does if it is confidential, does this protect the person or company if there's a future lawsuit? Who
Yeah,
holds the liability?
no, I think that's another excellent question, and we'll get into that in a little more detail in a moment. But the answer is, right, we are going to be responsible for what information we put in there and the output that comes from it, right? The liability that's associated with it. And this is where we're seeing trends. I mean, this is cutting edge sort of legal stuff, right? And so the idea then of where's the liability going to lie? If there's been a breach, there's been a hack, there are some laws that are associated with that already. That's not new stuff. But if you have agreements that with these AI providers, then that agreement is typically written to favor the AI provider and not the user. And so any liability would likely be addressed there. And a lot of times they are going to place the liability back on you in some sort of indemnification clause, right? A clause that says that if they're liable for something that they did wrong, you're going to cover them for it because you're the one that's doing the input. You're the one that's providing the information and using the output. So it goes back again in my mind to that relationship that's developed that I don't think people think through, right? They're just clicking a button and throwing the information in and getting the output they want and moving forward. But there's been an engagement there. There's been an agreement, and that agreement typically, unless you look at it carefully and negotiate it, is going to favor the person who puts it together. I mean, that's the way contracts typically work. So the liability, I think, is going to fall on the user more often than not in these situations. And I think with regard to the output, right, we'll talk about that in a second, it's also going to fall on the user. And I think that's where you start to see courts. I mean, I would say courts are starting to develop kind of a mistrust. And just to go down that a little bit further, if you're in the legal industry, you are aware that there are appellate cases now where lawyers are getting hammered, right, for using AI in preparing their legal arguments and preparing their legal briefs and submitting things to the court that are just not true. Wrong case sites or case sites that don't say what the lawyer said it said because they just ran it through AI. And it is not a defense in any way, shape, or form that, I used AI and I didn't know. That does not fly with the courts. And it's just, to me, that's a clear trend that and you see it even when we get to the last section where you're dealing with discrimination. And you might say, AI, I used AI and that's sort of neutral. And the regulations say, no, you've got to test and make sure it's neutral, because we're going to almost presume that there's some potential issues here. And so that's where I see this going. The output, the liability that's associated with both the input and the output is going to go to the user, the person who was responsible for putting it in and receiving and using the output. It's going to fall on the individual. And for us, if we're talking in an employment context, if it's an employee liability issue, it's an employer, right? We have general indemnification obligations under the California Labor Code that the employer is going to indemnify an employee. So yeah, that's long answer, sorry, but that's at the heart of this in my mind. I mean, that's really what we're trying to figure out from a liability standpoint, is how to protect against this sort of liability that is being foisted upon us with this new tool. All right, jumping back to the slides for just a minute here. So the Uniform Trade Secrets Act, it articulates what I've already said, right? The little second bullet point there. If we fail to take reasonable measures, right, to keep the information confidential, then it no longer carries the protections. And so inputting our trade secret information, inputting our confidential information in and of itself may be a measure that's not reasonable, that then publicizes our confidential, protected, private information. So that's just a clarification there of that we can't just use AI without thinking about it. Here's the end user agreements that I was talking about before, and the idea that the AI software is going to use the information, and that's sort of known and articulated in these license agreements typically. And so we're giving our secrets to the world, and it's going to be used. And so it goes just beyond the data breach, right? It goes into the fact that we have disclosed unreasonably our confidential and trade secret information. So what does that, end up meaning? Once it's out there, it's kind of gone. There's no way to protect it. And we're losing that trade secret status, that confidential status, right? The privacy aspects of it. So just some general recommendations that I think probably follow pretty easily from that, right? We want to have and make sure confidentiality agreements, right? Non-disclosure agreements, any kind of agreement that's talking about our information, we've got to have some limitations, some protections, some provisions that deal with how can you use AI with regard to our information. Policy, right? Training makes a lot of sense. And we want to limit what we're authorizing people to do so that we can use the disciplinary measures if people don't follow. And then the astute comment that was made, or question that was made, right? You want to consider, right, if you're going to have AI be a part of your, corporate strategy, then maybe you've got to go to and find someone who will build out that tool that will be select to you, and have an agreement with them that clearly confines and protects the confidential nature of the information that you're going to input into it. This is something that has to be thought through, and I think it's apparent that people are not, because At least the cases that I'm seeing, that they haven't thought about it at all in some cases.
I do have a question that's come through, Trevor.
Please. Yes.
Have there been any recorded cases in which confidential info uploaded into the AI model has hurt the company? Or is this all theory and better safe than sorry?
Yeah, that's a great question. I can't quote a case to you. I don't think we want to wait for the cases to come out before we make these sorts of decisions. I would suggest that it's pretty clear that just like we wouldn't put up a website and offer all our confidential information on it so that everyone could see it and find it, that would be analogous in my mind to throwing something into public AI and not, not expecting it then to remain and stay confidential. I think the case that I cited to you, which isn't specific to corporate information, but it does clearly articulate that, I mean, there's nothing more sacred in the law than the attorney-client privilege. That's how all attorneys are able to talk to people about everything. It's so sacred in the law that it's very hard to get around. And this is a case where a court said, yeah, you put in information into AI, it is not confidential anymore. So I don't have a case, but I have a lot of legal principles that are being applied that make it clear that if you're putting information into an AI tool, um, it is no longer confidential, and the law is not going to respect it as confidential. And so, will that end up harming a business? Yeah, I mean, that seems like that's the clear trend and the clear indication that we're getting from the law so far. So, okay, let's continue on this discussion path here. Just want to be cognizant of time. Sorry, I tried to. Okay. So, what is the liability for the output, the work product that we have? So, I don't think it's, a secret here that some AI anyway can have false, misleading, mistaken, flawed information. I think there's even a little line at the bottom now, and at least some of the AI tools that say, hey, this could be totally wrong, so be careful. And obviously, some tools are much better than others, but there is an obligation on the user, and that's where the trend is going. Is that the user, right, needs to be the one who decides and uses judgment with regard to the output. And so what we're starting to see and what we need to maybe continue to develop is, how do we verify? How do we demonstrate that the output that we received is verifiably useful? And I'll just go back briefly to the assessment that I've already offered, which is there are now a number of cases where appellate courts are saying to lawyers who are getting paid large amounts of money to represent clients, and they're running things through AI, and AI is making stuff up. And then they're relying on it without verifying, without taking the time to go and look at the case or look and see what the case says or see if that quote that AI gave it is valid. And they're sending that off to the court, and the court is doing its own research, finding out, no, that's not even true. That's not what the case says at all. And then reprimanding these attorneys for doing it. And it happens again and again and again. So the reliance on the output without any sort of verification seems to be an area where you're going to have potential liability issues. And I can't speak to all the industries that you're in, but as you use AI and there is an output that is provided, if there's no verification of that, I think you're running a risk of liability for that output. I mean, you're not going to be able to use as a defense, well, AI told me and therefore I'm not liable. That's not going to work. And so having some process in place of how you are allowing employees to use for your work that is being performed on your behalf that you're paying for, how are they going to use this tool so that the output is something that you can rely on? Because it is you who, at the end of the day, are going to be liable for that in an employment context. So that's the sort of policies that need to be developed and considered here.
We have a question that's come through, Trevor.
Please.
What is our obligation and liability when we indirectly use AI? For example, our
Okay.
ERP system integrates with third-party applications which have access to our data, and those application developers are starting to use AI in their products.
Yep.
Do we need to amend existing old agreements?
Yeah, I would say that I don't see how this is not going to be extended to a, sort of a second layer of use, and even an indirect use, right? You may have search engines or other sorts of tools that don't initially say anything about AI, but they're using AI in the background as well. So as you're looking to vendors or other people who are using AI that you're then getting some type of output for, and things that you're relying on, you've got to have the same level of verification for that as you do for anything that you're doing at your own level. If you're going to rely on the output, there's got to be a way that you can verify, and you are aware that this tool has been used in the development of that output. There's got to be a way for you to verify that that output is something that you want to rely on, right? And so, I mean, in some regards, right, that just makes it feel like I'm doing double work, right? I go out and have the AI tool produce for me something, and then I've got to go and verify that what they produced is right. So why didn't I just go? And I think that's maybe where we're finding that in earlier stages of work output, AI can be really helpful because it can quantify and give us a like the scope, but then ultimately you're left with needing to rely on the judgment, the human judgment that is associated with getting into the nuances and details. And I know every industry is going to be different. I totally understand that. But again, anecdotally, let me share, right? I do a lot of contract work. And so when I have clients all the time now say, we had our other attorneys take a look at this, and here's an agreement that we'd like you to just go over and see if we got it right and all of that. It's an AI agreement. I can tell right from the beginning, and it's terrible, right? It's awful. And so then we say, okay, thanks for that. We'll make some revisions, and then we basically rewrite the whole thing. So, I mean, that is how it's being used, and the output, right, is not up to par with what the human judgment would be if as they prepare it. Now, in my own work, right, I might, as an initial, say, give me all of the bullet points that I need to know for this kind of an agreement or this kind of dispute or this sort of claim, or right, ask for some broad, but not all the nuances, not all the details, because I'm going to have to rely on that. I need to know that it's right. And so I think that's where we're kind of starting to balance it out and figure out how to use it. So, yes, your agreements with vendors who you feel like are using AI to give you an output that you're going to rely on, absolutely, you need to have some sort of provision, discussion. There needs to be transparency there so that you can have them verify to you that the output that you're relying on is trustworthy, because that, I think, is a real aspect of all of this. And I think, just like the second bullet point says here, neglect, lack of knowledge, right? That there's errors in it, right? We know we used AI, but we didn't know that it was incorrect, right? That is not going to be an excuse. And you're going to see that again when we get to the last section dealing with the discrimination components and the civil rights division and what they've put together. So
We have
Question,
another question. Yes, we
please.
sure do. What if the third party we work with never set an agreement with a client to perform tasks and provide info through AI? Payroll companies are auto switching to AI.
Yeah, that's a great question, and it's very common, right? That you have an agreement, it's just not in writing. I mean, that's anytime you have any sort of relationship, certainly a business relationship, that is not there's an agreement there. It's just a verbal agreement or it's an implied agreement. I mean, under the law, you've got an agreement. It's just that it's not in writing and it's not clear. And so certainly notices and disclosures from them is what you need to start with. But if there's an output that you're relying on, you need to have some sort of verification that you can rely on that output. And if they're using AI to produce something, that's where you need to step in. And yeah, it's not going to be a very common thing right now because people are just relying on one another to use it wisely. But that seems like the kind of thing that if you're prudent in this area, you're going to say, how are you using it? How can I rely on it? What are you doing to verify? And get that into a written agreement so you can rely on it and then deal with the indemnification issues. If you screw up because of your use of AI, you're going to protect me, right? That's what you want in the agreement. When the lawsuits come and everything comes because someone used AI and it screwed everything up, whatever the situation was, you're going to want to be able to say, okay, I relied on them, and there's a contract here that says they have to pay for my attorneys, pay for my liability, get me out of this thing. That's what you want in any sort of agreement like that. And then that is what is going to help move this to an assessment where the folks who are using the AI are doing it responsibly and making sure that they can verify everything that is their output. Yeah. Okay, we'll keep marching here. So I think we've talked about these recommendations a little bit already, but we want to have some way to verify internally, right? What is our process? How do we use it, and how do we verify it? And so that's an internal policy. And then we want to restrict and make sure that the people that are using it, that we're paying for and we're receiving the benefit of, are using it in the way that we want them to use it, right? And that, I think, really does go to an understanding of how we want it used, right? And we put a little thing in here. Maybe it's better to selectively permit than selectively prohibit. That's an idea of starting with no AI use unless we say it's okay, and then going through your processes and figuring out where AI works and makes sense, and saying, oh, okay, you can use it for this. Okay, you can use it for that. It's just a model that you can consider. But I think that you want to have clear policies and practices that you can stand behind when you're using AI. And again, anecdotally, law firms right now are all going through this because they don't want to get reprimanded by courts for giving false information to the court. That's, I think, just a really good, clear, anecdotal application of these principles. And I presume that it's going to come down ultimately in all industries, probably already happening to some degree. And we want to get in front of it a bit. Let's just turn now to the concept of discrimination and see how maybe there's some real a little bit more practical application of some of these principles as now administrative agencies and legislature is starting to try to grapple with this. So there is, under the Fair Employment and Housing Acts, some new regulations that start to speak to the use of AI in employment related decisions. And they speak to already that these AI results can have sort of a disparate impact, algorithmic discrimination, right? And what it means is if you're familiar with discrimination law for the last several decades, right? You have kind of two kinds of discrimination. I list them there in the sub paragraph under the or sub point, right? You've got disparate impact and disparate treatment. And disparate treatment means that I treat you differently individually because of your protected classification, right? I don't like men, so I terminate men, and I'm terminating you because you're a man, right? That's disparate treatment. Disparate impact is different because the policy, right, the practice is by definition sort of neutral, but the impact of that is discriminatory. One of the very early examples was the requirement of certain graduate degrees that had a disparate impact on certain folks of certain races. And so that impact, right, could be demonstrated through different algorithmic type of assessments, analysis of the neutral on its face policy, but it had this huge impact on a particular classification. And so this AI sort of algorithmic discrimination, it falls into that disparate impact type of an analysis that you would see. And that's what the law is trying to grapple with here, right? Just from a very cursory review at the top level, one would think, okay, if I use AI, which is neutral, it's not a human being, it's just taking the facts and plugging them in. If I use that in recruitment or promotion or hiring or terminations, right? I should be able to avoid a discrimination type of lawsuit because I can just say AI told me to do it. I didn't even use human judgment. I didn't even write. I threw everybody's resume in there. They told me who was the best one. And so the regulation of that idea is what these rules are getting at. And they're saying you can have a discriminatory outcome unless you, as sort of the human driver of this, do some sort of audit or testing to be able to demonstrate that the AI processes are not discriminatory, even though they seem neutral on their face, right? So that's what we're getting at here. They come up with this term automated decision systems, right? Which is what I'm referring to, right? There's no human involved. It's just automated, right? And we just decide, here's your productivity over the last 2 years. Here's your performance reviews. Throw it into AI. AI tells us who, right? Who should get a promotion, who shouldn't, who would be the best one to receive that benefit. And so if things are derived from an automated decision system, from an AI tool of some sort, right, then we are going to have to be able to demonstrate at some level that the process is not discriminatory, right? So recruiting, hiring, promotions, application screeners is an example. This is what we're talking about. And the guidelines from the EEOC and from the civil rights folks in the state, they have just said the law prohibits discrimination when we use AI in all of the different aspects: monitoring, assessing productivity, setting wages, right? And that what they're saying is that you need to be able to demonstrate that your use of AI is not discriminatory. They give some examples there. They're reasonable examples. They're not the best examples, but I'm sure we'll get better examples as this goes along. So I wanted to just reference here as well that as we're talking about the laws, there are some bills that were proposed this last legislative session that did not pass, that I think inform kind of where the law is intending to go. You can read those bullet points there. These did not pass. I want to be clear about that. But the concept that you'll see in both of them is that if you're going to use AI in some fashion to discipline, to terminate, to hire, to fire, they both talked about needing to provide notice in some form or another to the employees, to the applicants, that AI was going to be a part of of this process, right? And the notice is meant to identify, to disclose to the individual that they could have a claim if they feel like there was a discriminatory type of output. And so I think that that's probably where this will end. These bills, again, didn't pass, but that idea of transparency, disclosure, notice, right? Letting people know that, yes, we are using AI so that then we can be held accountable for that use. So in the end, under the regulations that have come out, right, there's this idea that we will need to do some sort of audit, have some sort of testing that's going to demonstrate that our use of AI in the employment decision-making process is not discriminatory. And that does become part of a defense in that disparate impact type of claim. So I think that's where, we can get ahead of this a little bit. And if we're going to use any sort of AI system in our employment decisions, from recruiting to termination, right? Anything in between, we want to have in place some sort of processes that we can show that they're not biased. Some type of testing, and I'm presuming there's going to be small cottage industries that are created that can do that for us. But the testing that is offered then becomes a defense to any sort of claims that that the AI tool was discriminatory, and that's going to be a part of the law, I think, moving forward. All right. I think we've kind of covered all of this. There is a component that, where we're training the tool, as well as training, human beings to use the tool, and kind of doing that training together, I think would be valuable as a defense, so that there's an ability to illustrate that we've been involved in the process from the beginning. And we've been, training this system so that it weeds out any biases. And so I think that's the essence of it. I'd love to take questions if there are any more.
Absolutely. Yeah.
Yeah, go ahead.
Thanks, Trevor. So yes, please type in more questions that you have into the Q&A section. Here is one that's come through. Since it's recommended for company policy to say that the employee is solely responsible for their use of AI, including improper uses, does that mean that a company can also make the employee indemnify it for the employee's improper use of AI?
Yeah, that's a good question, and I think that we want to make sure employees understand that they are ultimately going to be responsible for their use of AI. That is what is going to allow us to discipline or take some type of remedial action if someone's not following our policies. So we definitely want to be articulating to employees through policy, through training, that they have their own obligations individually to not use AI improperly or outside of the policies and practices that we've put in place. Having said that, though, like I said before, there's a general obligation for employers to indemnify their employees unless it's like willful, right? They're intentionally using AI to harm the company, something like that. If it's just a typical negligent act of using AI that gives us output that isn't verifiable or accurate, then we ultimately are going to be responsible. We, the employer, the company, are going to be responsible for their conduct. That's that's how the employment relationship works. So you definitely want employees to understand that they're individually responsible for any use of AI, because again, that's how you're going to discipline them. But the overarching liability is that we're going to be responsible, the company's going to be responsible for that error and for that output. And then therefore there's a need to indemnify them and make it right with whoever it harmed among clients or others.
Thank you. Okay, wonderful. Another question. When building an AI policy, how should a company decide what AI uses or uses in programs to restrict?
Yeah, that's another good question. I think in the end, um, there's going to just have to be some testing to figure out how these tools make sense for each industry, each company, each employer. And I mean, it does make sense to me that we start by restricting until we know what it is that we as an organization want AI to do for us. And so, certainly, a policy that says you can only use AI as authorized by us, and then the follow up is, well, what did you authorize? And maybe it's nothing initially, or maybe it's just stuff that we're very, very comfortable with, and then it expands over time. So to me, a policy that would be defensible and I think most practical is to start with, we the company decide how you can use AI. And you could even have a system there, right? Because it's an ever changing sort of tool that says, if you want to have use of AI, come and let us review it, right? Here's the process that you can use for us to verify that you can use AI in this way. I think from a liability standpoint, you want to control how it's used, because in the end, as an organization, you're going to be liable for it. And so, besides reputational sort of stuff, which I think is what these law firms are going through, there is the potential liability that's associated with it as well. And all of that comes back to the company. So it just makes good sense that you control it, and you control it from the standpoint of saying you don't use it unless we say you can, and you use it the way that we've decided that you can. I just wouldn't have it be a free for all. That does not make sense to me.
Perfect. Thank you so much. Another question, other than a potential data breach, why else should a company be potentially concerned about sharing confidential information with an AI?
Yeah, I think the data breach is one avenue that it's getting some coverage in the news. It's chat bots and things like that that are able to kind of hack into things. I think that's a real concern. But I think even more problematic, at least to me, is the idea that the confidential information loses its protections merely by just putting it into the AI. I mean, that's the case that I started with. That's the case that I think really illustrates the need to regulate what it is that we're offering to these tools, because I think that the initial consideration should be that if you put it in to an AI type of tool, it is no longer yours, and you have lost all ability to protect it. And so I know we've probably got some health folks in the healthcare industry, right? All of the confidential patient information. I mean, we've got to make sure that if we're inserting that kind of information into an AI type of tool, that end user agreement is protecting that information. It just does not seem that you can reasonably put confidential information into a tool like that and then expect that that is remaining and keeping its confidential nature. Another way to look at it is that there should be very low or even no reasonable thought about privacy, an expectation of privacy. That you have no expectation of privacy when you're using AI. And I think that needs to be the model that we come from. That whatever we put into an AI type of tool, you're spreading it to the world. It's not confined to you unless you've got that end user license agreement that protects it. And I think that's going to be very uncommon. That's going to have to be something that's negotiated with a private organization that builds out a model for you. The standard AI tools that are available to everyone, I don't think you're going to have any protections there at all.
Thank you so much. And we have time for just a couple more questions. Another one that we have, how much transparency should companies provide? And what happens if AI systems act unpredictably, especially with payroll companies and job posting sites like Indeed?
Yeah, I think that the transparency is going to depend on who it is that you're working with. I think from a transparency standpoint between you and a vendor that you're relying on, I would expect 100% transparency, especially if I'm going to be relying on their output. I think if we're talking about transparency to the public or to people that we're offering information to, I think those sorts of notices and disclosures are probably going to be more regulated by the law and what we have to offer up. But I think that as you're receiving information from people, I think you want to be able to let them know that you're keeping it confidential, that you're not going to use it in these ways. And if you are, then I think you want to have in the agreement that you have the right to do that, right? That if you're taking their information and they expect it to be confidential, and then you're putting it into some AI tools that breach that confidentiality, right? I think you're going to want their consent to be able to do that. So, a great question. I just think it's going to depend on who you're dealing with. And if I'm relying on the output, I want 100% transparency. If I'm the one that's creating the output and doing using the AI tool, then I'm going to want consent and disclosures to make sure that I can do whatever I'm doing and I'm protected on that end of things.
Wonderful. Oh, yep, and she says thank you. So I believe that will wrap up our questions. Trevor, would you mind going to that next slide so we can show off what's next for
Absolutely.
Bender U? So we are going to be talking about alternative risk, and captives are a really wonderful way to approach that. And we're specifically going to be talking about health insurance captives. So if you grab out your phones and scan that QR code, that's on Thursday, June 18th. We'd love for you to join us. It's going to be a very interesting and educational class. That's it. So thank you again to Trevor for sharing with us today. We appreciate you all for taking time out of your busy schedules to join us for today's Bender U. As a reminder, this session has been recorded, and both the recording link and a copy of today's slide deck will be emailed to you following the webinar. If you have any questions that arise later, we know that tends to happen, please feel free to reach out to us. We are happy to help. But thank you again to everybody, and we hope you all have a wonderful day. Thank you again to Trevor. Thank you, Keck.
Thank you.
Thank you, Trevor.